if we only take one thing away from this video, it should be this. DBA and trademark, those are both nouns. They are not verbs. You don't DBA something and you don't trademark something. Hi everyone, I'm attorney Aiden Durham with 180 Law Co. in Colorado, and welcome back to All Up in Your Business. We are gonna do another exciting round of responding to your comments and answering your questions. This time around, I'm gonna focus on your trademark related comments and questions. Figured, I get a lot of really great questions and stuff in the comments from you guys all over the place. Figured focusing on trademarks for this one would be easier for me and hopefully easier for you guys to get the answers that you're looking for. Maybe next time we'll do some more LLC related questions, but trademarks this time, okay? Before we get into it, be sure to like, subscribe, and share, and check the description for links to additional information and resources, including a link to check out my freshly updated and revamped Brandish course. If you're not already familiar, Brandish DIY Your Trademark Application is a step-by-step online course that teaches you exactly how to prepare for, complete, and submit a trademark application with the USPTO without a lawyer. And I just recently launched an update with a lot more information. It's broken up into 6 different modules going through all of the steps to figure out what your trademark is exactly. Make sure it's worth it to register the trademark, and then making sure your trademark is available to register, and all the important things that you need to know when it comes to registering a trademark. So again, check the description for a link to learn more about Brandish. All right, let's get to your questions. On the trademark application, what if I haven't sold my goods yet? How will I know which date to put for the first use of the mark in commerce or anywhere? So if you are not yet using the trademark in commerce, then you would want to file on a 1B intent to use basis. The application only asks for the date of first use if you're filing on a 1A basis, which means you're already using the trademark in commerce in connection with the sale of your goods and services. If that's not the case for you, then you can file on a 1B basis instead, and the application won't ask for those dates. Can you DBA a trademark? Can you DBA a trademark? So I think if we only take one thing away from this video, it should be this. DBA and trademark, those are both nouns. They are not verbs. You don't DBA something and you don't trademark something. Something can be a DBA and something can be a trademark. Your DBA can be your trademark, and your trademark can be your DBA. If you're asking, can you register a trademark for your DBA? Yeah, absolutely, assuming you are using it as a trademark. And if you already have a trademark registration, or if you already have a trademark that you want to use as your DBA, yeah, same thing. Is logo and brand name the same? My brand name is in my logo, which should be filed. So a logo and a brand name are not necessarily the same thing. A logo in the trademark world is considered a special character or a design mark, whereas a name or just something plain text is considered a standard character or a word mark. When you register a trademark for a standard character word mark, you're protecting that trademark in all forms, regardless of how it appears. There's no design or stylization to it. So your rights apply strictly to those characters regardless of how they appear. Versus a design mark like a logo, registering a design mark is specific to its appearance. The overall design and stylization and appearance of that logo is what your trademark registration applies to. If you have a literal element like your business name as a part of your logo, you do get some rights for that literal element, but it's much weaker and it's still very specific to how those words appear in your logo. So if you're looking to protect your brand name in itself, regardless of how it looks, then registering the name as a standard character mark is the best bet. If you want to protect your logo and that design and exactly how that looks, then registering the design mark for the logo would be your best bet. I cover this topic in depth in Brandish in my online course. So if you're not sure of whether it's best to register the trademark for your logo or your brand name or maybe both, I highly encourage you to check out Brandish because I walk you through exactly how to figure that out. Can I use date of first use as date I acquired domain name if I immediately tried to sell the name as a brand? Acquiring a domain name in itself is not considered use of a trademark in commerce. Use in commerce means you are actively using that trademark in connection with the sale of your products or services. Merely purchasing a domain name has nothing to do with selling your products or services. It's in preparation for that, but you're not using the trademark yet. Even if your services were selling domain names, purchasing that is still not using the trademark. That's basically like purchasing inventory, like you would if you're selling anything else. So it would really only be considered a trademark if you're using that trademark in connection with your business selling domains or brand names, which it doesn't really sound like is the case here. But the strict answer here is no. Acquiring a domain name, that date doesn't count as use of a trademark. Thank you. You're welcome. What about trademarking a book like The Hobbit? Can the entire book be trademarked if it will be part of the series? So I included this response to it that said copyright it, because that's partially correct. So you can't register a trademark for a book, not the contents of a book. The contents of a book would be protected by copyright, like this second comment said. So you can register the copyrights for the book to protect the content of the book. That won't apply to the title of the book though. Book titles can only be registered as trademarks if they are part of a series. So like books like The Hobbit or Harry Potter, or you guys remember those old Chicken Soup for the Soul books? When you have a series of books all published under pretty much the same title, those typically are going to be eligible for registration of the trademarks for those book titles. But again, the trademark registration doesn't protect the content of the book. That would be under copyright. Do I need a lawyer's help in obtaining a trademark? Typically, no. The only requirement to have a lawyer applies if you do not have a domicile address in the United States. So if you don't have a physical presence, whether it's a home address or a physical business address in the United States, in that case, you do need a lawyer to represent you throughout the process. But if you have a domicile address in the US, then it's perfectly legal to do it on your own without a lawyer. However, it's much more complex than it looks at the outset. The questions seem pretty straightforward, but they can have a very important impact on your trademark registration and your trademark rights after that. So it's still always best to have an attorney help you with it to make sure you're getting the most out of this trademark registration that you can. Secondary to that, of course, if you can't afford to work with a lawyer, would be to learn how to do it yourself so you can do this process as best as possible. And of course, that's where Brandish comes in. I teach you all the important things that you need to know about the trademark application and the registration process so you can safely do it on your own without a lawyer. What is first use versus first to register? Great question. So in the United States in particular, it's different in different countries, but in the United States, trademark rights arise out of use of the trademark, not registration. So the first person to use the trademark in commerce has priority of rights in that trademark, regardless of whether they registered the trademark with the USPTO or not. And just because someone registers a trademark before you do, doesn't necessarily mean that their rights are stronger than yours if you were actually using the trademark in commerce before they did. So that's what that means. First use is whoever used the trademark first. First to register is whoever registered it first. There are a lot of jurisdictions where it's first to register. Whoever registers this thing first wins and owns this trademark. But that's not how it works here in the US. It's first to use. Can you please do a video on intellectual property LLCs? Well, I don't know necessarily that that would be appropriate for an entire video. It's not, an intellectual property LLC isn't like a formal thing. There aren't really different types of LLCs. There's an LLC that can be used for different reasons. I think you guys just got a nice little cameo of Rocky there. Hi, Rocky. LLCs can be used for different purposes, different reasons, such as holding intellectual property. But like the setup and the process of operating an LLC for that purpose is exactly the same as setting up any other kind of LLC. So I don't know. Comment below if more people are interested in learning about these intellectual property LLCs. If it seems like there's a lot of interest in it, then maybe I'll do a whole video on it. All right, this one's kind of long. I'm just going to speed through it. Excellent content. Thank you. What if the name that I intend to use is a Chinese company got it, barely realized, nothing showed up. 6 months ago, you have a product and brand, a Chinese company, have it on the USPTO page, but they intend to use it on office products and I intend to use it on beauty products. Can I still apply for my brand in the beauty field? Okay, so to sum it up, this person wants to use a name for their beauty products. Notice that a Chinese company is using this name for office products and I guess has a US trademark registration. So it always depends. Strictly speaking though, it's very common and perfectly fine to have identical trademarks that are used on completely unrelated goods and services. So if this company, the fact that they're a Chinese company is not really relevant, but if another company is using a trademark on completely unrelated goods and services, then it's still totally possible for you to get a registration for that same mark. Again, it always depends. Looking just at these facts, office products, beauty products are pretty unrelated. So in a vacuum, I'd say you probably have a decent shot of getting the trademark registration. But of course, I can't say that for sure. Do you think Crown Body and Soul is a weak trademark? It's a salon, metaphysical supply shop, offers products and services for hair, body, and spiritual practices. Good question. So what this comes down to is descriptiveness. If you have a trademark that is merely descriptive, meaning it merely describes the goods or services that you're offering or a characteristic or ingredient or result of those goods and services, the USPTO considers this to be merely descriptive and they won't allow it to be registered on the principal register with some exceptions. So here we know body and soul is descriptive. The term body and soul, that's descriptive because your products and services have to do with your body and your soul. Crown here though might be questionable, gray area. Crown has to do with, the top of your head and your hair, and crown is also a spiritual word. Crown has significance in the spiritual realm too. So if I had to guess without doing any additional research behind it, I'd say that the USPTO would probably consider that to be merely descriptive and therefore it would be kind of on the weak end. But, I've been wrong about things before. So I thought this one was funny. Finding a name that hasn't already been taken has been a huge pain. That is true. There's a joke in the trademark lawyer world, that there are no good trademarks left. And it feels like it's true sometimes, that anytime you come up with a very clever or original name for your business or for your products or services, you start looking it up and boom, look, it's already been taken. Someone's already been using it. But I promise you, there are still some good trademarks out there. But yeah, it can be really difficult to find a good, strong, distinctive name that hasn't already been taken. My best word of advice with that is make something up. Make up a word, combine a few words, make up some term. That's usually going to be your best bet. Can a trademark ultimately protect my logo? Well, yeah. Well, so again, trademark is a noun. You register the trademark. Your logo is a trademark, and you can register that trademark with the USPTO. And yes, absolutely, that's the goal, is to protect your logo and prevent others, your competitors, from using it and, profiting off of your brand recognition or your name or your hard work. So yeah, registering a trademark can absolutely ultimately protect your logo. However, this fella says registering a trademark isn't always about name recognition. Although branding is great, the real reason you would want to do it is tax reduction. For example, Delaware or virtual aspects fall under trademark, file a shell company, you lease it to you. Okay, so there's some truth to this, but it's kind of misleading. So there's this thing that people refer to as the Delaware loophole, where Delaware has a corporate income tax, but they don't apply to intangible assets like trademarks. And so what a lot of very large corporations do is they set up a shell corporation in Delaware where their main company assigns their trademarks to the shell company. The shell company license or leases it back to the main operating company. The main operating company pays money to the shell company, and shell company doesn't have to pay income tax on that payment from the operating company. And so for very large corporations, doing this can result in a much lower tax bill overall. But the important thing to know is that this is corporate, so it applies if you are a corporation. This wouldn't apply to pass-through entities like an LLC. And you also have to take into account the administrative cost and hassle that goes into having a shell company in another state. It's not free to set up a corporation in Delaware, so you have the formation costs of that, you have annual franchise taxes, and you do still have a corporate income tax. And you have costs associated and administrative work associated with that whole leasing or licensing between the two companies. So for most of us kind of small players, small businesses, doing this, maybe it would lower your taxes a little bit, but I would venture to guess that it would be offset by the additional cost of taking this tactic. Again, this works for very large multi-million-dollar companies who have lots of trademarks. Then yeah, this is a fine tactic. I strongly recommend that you talk to a tax expert and an attorney before moving forward with something like this, because for most of what I presume is my audience, most of my clients, this would just be a waste of time and money. It wouldn't do you any good. But thanks for the comment. I completed TEAS a couple of months ago, 2 classes. If I get denied due to a weak trademark, wondering whether to go ahead and use the name in business anyway or change the name completely. So yeah, this is a conversation that I have pretty often with a lot of my trademark clients. Just because you don't get a trademark registered, that doesn't mean that you can't still use that trademark for your business. It simply means that you can't register it. Of course, the fact that the trademark isn't available to register, that could mean that there's already a trademark registered for that, which could mean that there's some other company out there that might be able to take some legal action against you if you do continue using that name or that logo or something. But just because you can't get a trademark registered doesn't automatically mean you can't use it. So, if your trademark gets denied, you still have the option of using it anyway. There might be some risk associated with it, but, you can continue using it until a court or a judge or a contract says that you can't. All right. That's all for this episode, folks. Lots of great trademark questions from you guys. Again, don't forget to check the description for links to additional information and resources, including a link to sign up for Brandish, where I teach you step-by-step how to prepare for and submit a trademark application with the USPTO without a lawyer. Thank you all so much for watching. I'm Aiden Durham, and I'll see you next time.